not able to see Mr. Rangnath. I think he lost the connection. Sir, at 6 o'clock, if you permit me, can we start the session, sir?
Please, please.
Good evening, a warm welcome to all of you to the webinar series hosted by Advocates Association Bangalore. We have with us today illustrious and young, energetic advocate, Mr. Sajjan Povayya. Sir, it's an honor to have you with us today. Welcome to the webinar.
Thank you.
Now I take the privilege. Yes, sir. Now I take the privilege of, though sir is very well known in the fraternity, I take this privilege of reading out his profile. I've tried to condense it. Mr. Sajjan Povayya graduated as a gold medalist with a bachelor's degree in arts and an honors degree in law from National Law School of India University. He was a Chevening Scholar at the London School of Economics and Political Science, from where he obtained a master's degree in law. He has been a fellow of the Society of Advanced Legal Studies, London, and admitted as a solicitor of the Supreme Court of England and Wales. Mr. Povayya has been practicing before the Supreme Court of India and various high courts on matters relating to constitutional law, corporate and commercial law. He is designated as a senior advocate by the High Court of Karnataka. Mr. Sajjan Povayya also devotes considerable time to represent social and environmental causes of public interest in the Supreme Court of India and multiple high courts across the country. He was officiated as the Additional Advocate General for the state of Karnataka and was one of the youngest to occupy that position. In 2016, LexisNexis listed Sajjan Povayya as one amongst the 100 legal luminaries of India. He has been voted by Law Asia and Chambers and Partners as one of the Asia's leading attorneys. Sir, today we have a legal luminary and Asia's leading attorney with us. Sir, I extend a warm welcome to you on behalf of Advocates Association Bangalore.
Thank you, Vikram. Thank you very much.
Over to you, sir.
Thank you for the unnecessary introduction. I think the best introduction for me and the proudest introduction for me is that I am a member of the Bangalore Bar and I'm a member of the Advocates Association. It's a pride for me to see my dear friend Rangnath on screen in one corner. He chairs the association. I must say, despite all my work now being predominantly in the courts in the northern part of the country, I have not found a bar more friendly and more supportive than the Bangalore Bar across all courts. The beauty of our bar association is that we are not restricted to a particular court or a particular kind of practice. We don't call ourselves an appellate bar or a competition bar or a technology bar or corporate bar. I think we span all practice verticals. We span all courts, and therefore that brings in a particular fabric to the association, which is, I think, unparalleled. I must say I'm proud that I'm a part of this association. Now, with those words, let me be very unorthodox, if I can say so, in presenting to you a little bit about what information technology and intermediary liability is all about. Friends, I don't stand here to speak because I'm any expert in the field. I'm not. I don't stand here because I understand all of the law relating to information technology. I do not. I stand here simply because this is an area of work, and this vertical of work has taken me into multiple forays of various litigations in the country. And therefore, I possibly have done a little more work in this area as compared to many of my friends in the bar. And therefore, I think I can share a few of my experiences. So please see what I say today as a sharing of my experience rather than a rendition of what the law is. Please see what I say today as a sharing of the problems that I face in this area of practice rather than trying to identify what is wrong with the law. I don't think I have reached that stage in my life where I can tell all of you, my friends, what the law is and also identify the pitfalls in the law. I'm just sharing my experience. I will be brief in terms of what I will present, and I will keep as much time as we can afford today to receive questions. And the tone of my conversation also will not be simply rendering what the act says and what the judicial decisions say, but it will also be oriented towards what should we do when we file an action against an intermediary, or when we want certain reliefs against content on the internet. And what should we do if we are called upon to defend an intermediary, or if you are called upon to defend a particular content on the internet. We are, I think most of us here are members of the bar, and maybe there are some non-lawyers, but I take it that most of our work is in the trial area, and therefore I don't think we should really waste our time in terms of the nitty-gritties of trial practice. Now, what are we talking of when we speak of Information Technology Act? And what is this animal called intermediary? And what is this whole concept of intermediary liability? We should be clear on one thing, that technology is always ahead of the law. There is always a scenario where technology gallops much faster and law really catches up with it. Therefore, when you talk of technology, and then when we talk of law and the interface between law and technology, please don't mistake yourselves or kid yourselves to go towards the Information Technology Act alone. Information Technology Act is a piece of legislation on technology which has come about during our lifetime as lawyers. It has come about at a point of time when technology, and particularly information technology and web-based technology, has had a sense of novelty. It has come about when the transition in technology is so fast that we can today have possibly a virtual conference, which was impossible for 30 years ago or 40 years ago, or even for that matter, technically speaking, 25 years ago, a web-hosted conference of this nature was not possible, simply because the technology didn't support it. But does that mean that when we talk of technology legislation, we only talk of Information Technology Act? The answer clearly is no. Let's just, as students of law, walk the path of how law has followed technology. See, at a point of time when the steam engine was invented, there was then the concept of a boiler, and the boiler generating power, and that boiler's power being generated and transmitted to the wheel or transmitted to the spinning mill, and therefore steam engines started running mills. Steam engines started running automobiles. And at that point of time, what did the law do? The law actually caught up with that by bringing the Boilers Act. And they said, okay, a Boilers Act will say the boiler must be of this girth, it must be kept in a particular manner, you need to have a license, you need to have somebody to look after it, etc. Going back, the Boilers Act was a technology legislation. It was simply to answer a particular technology that came in, that legislation came to govern it. So every time the law governs technology, it actually brings about a technology legislation. Believe me, a boiler and steam engine was very novel, and there was a novelty concept to it at that point in time. Today, it is, of course, archaic. Walk the path downwards. When we had scenario where wireless communication started, and before telegraphy was invented, wireless communication was unknown. But when telegraphy started, wireless telegraphy came in, and therefore wireless communications came in. What did the law do? The law brought in the Wireless Telegraphy Act to govern that technology and to try and control liabilities in that technology, to control the rights and obligations of parties who use that technology, etc. Therefore, the Wireless Telegraphy Act was a technology legislation. The telephone legislations which came in were a technology legislation. Come about, when radio communication started, it was again novel technology. And you had legislations to govern broadcasting, to govern how transmission of information will happen on radios. More recently, when we really had television, and then if you look at immediate previous generation, when satellite broadcasting started, you had a whole host of legislations coming in to govern them. And all of them, therefore, were answers to technology. But what is it that is different with the Information Technology Act? The difference is that the Information Technology Act came in at a time when web-hosted services and information technology-based solutions started converging, that every aspect of previous technology could now be done on the net. Communication happened on the net. Sharing of information happened on the net. Trade and commerce started happening on the net. I would want to, in my own words, there is no, of course, benchmarking for the internet this way, but to my mind, the web or the internet has also gone through a particular process of development. We had Web 1.0, which was basically a static web. A lot of you in my age vintage and possibly older to me will realize that when we went to school, we really had a black telephone where we had to book trunk calls, and really not have direct one-to-one communication. And if we really needed anything to be sent, it was fax communication. There was no internet, there was no email. And when email came about, that is right when we were leaving school and possibly getting into college, slowly email started percolating. And we had a TCP/IP account where you would dial on and send one particular static message and then dial up, dial close and get out, which was basically therefore a static web. There was no interaction between the human being and the web. Web was only a medium for transmission of certain information. That was Web 1.0. Then much later, when we joined the bar and then looked at technology actually interfacing with the law, we came into Web 2.0, where trade and commerce started happening on the net. There was two-way communication that was happening on the net. There was not one-to-one communication, but there was one-to-many communication and many-to-one communication. For example, you could basically web host certain services. The concept of DTP started, which is nothing but desktop publications. Now, desktop publishing is again a very, very connected concept to the law. Traditionally, if I had written something, I had to print it, I had to publish it. There were particular regulations that I had to follow in terms of printing and publishing it. There had to be a named publisher. There had to be a named copyright owner. There were certain methodologies by which certain publications required licenses. If I needed to actually put up a magazine, I needed a registration under whatever the legislation was which governed the press. Therefore, publication was really a concept which was complex. But with the advent of technology, we started having desktop publications where I would write something and simply from the top of my desk, by the click of a button, I would publish it by hosting it on the internet. That was Web 2.0. We started getting into using the net as not just a medium of one-to-one communication, but also as a medium of broadcasting to the larger masses. Then we came up to Web 3.0. Web 3.0 really is a scenario where the web itself started having a good deal of artificial intelligence. The web would decide in terms of how it interacts with an individual. We have had places where poker players play games on the net, of course, with individuals in other parts of the world, but there are lots of games played with the internet itself because there is an artificial intelligence playing a game with you. Chess players play their games with artificial intelligence on the net. Now we are going into Web 4.0, where the internet will be connected to the material world in the sense that my house will talk to my car will possibly talk to my laptop will possibly talk to my watch will possibly talk to my air conditioner, and my air conditioner will possibly talk to my refrigerator, indicating whether there is a supply in the refrigerator and whether an order must be placed, whether the air conditioning is comfortable enough because my car is approaching my house, and closer it gets to my house, I need a particular ambient temperature in my house. The car will in turn communicate with the fuel station in terms of indicating what is the closest fuel station that the car should get fueled at. What is this? This is the Internet of Things. As we speak, gentlemen, we are going through a scenario where we have an Internet of Things, where individual aspects of our physical brick and mortar system is getting connected with each other on the internet and talking to each other on the internet without a human interface. We have cars now which identify when it is driving as to whether if you are driving on the left or right of the road, depending upon which country you are in, it will identify human beings walking on the road or animals on the road and automatically decide whether it must brake or not brake. It will automatically decide whether lights must dip or dim depending upon the intensity of light that it gets. Now, these things are really happening from what perspective? It's happening from a perspective that your car is constantly monitored on the internet through GPS, and that monitoring really takes care of the methodology in which the car must drive, the adaptive technology in which the car must take forward, etc., etc. Now, under those circumstances, when we have an internet which is completely connected to the physical existence of our world, and these aspects of our physical existence talk to each other, what should the law do in terms of governing these relationships and these transactions? The answer clearly for that is that we needed a comprehensive legislation, and for some extent I must indicate that the comprehensive legislation at least came about from a perspective, or at least an attempt was made from a perspective of bringing in the Information Technology Act. Let me come to what the Act says. The Act certainly is not the best answer to governing technology and the interface between technology and human beings. Absolutely not. That situation, I think, will take a little more time. But it is, I think, a fantastic beginning that we have an attempt to bring about a comprehensive legislation to govern relationships on the internet, to govern interpersonal relationships, and to govern one-to-many relationships. With that, let me come to this animal called intermediary. All of us as lawyers, and mostly the litigators, have looked at Information Technology Act as one other legislation where if we need to sue and if we need to actually initiate some action to bring down some material on the internet, we will use the Information Technology Act and initiate a legal action. But I think it is more. The Information Technology Act creates an ecosystem for transactions on the internet to be governed. The ecosystem starts from the fact that there is recognition of digital documents. There is recognition of material in electronic form, which is not in physical form. And number one. Number two, it also then recognizes particular status for particular people vis-a-vis that electronic information. Every electronic information, by virtue of the Information Technology Act, has the following. It has somebody called the originator of that information. The originator of that information is nothing but, I'll compare it to a physical space. It is nothing but the author of actually the document. If I have written a document, I am the author of the document. But if I put something on the internet, which is in electronic form, I am the originator of that information. I, as the originator, may possibly, I'm saying may possibly have the same status of an author, may be entitled to the same rights of an author, and may be exposed to the same liabilities of an author. We will come to those nitty-gritties a little later. Now, once you have the originator of the information, you also have the recipient of the information, and the Act recognizes somebody as the recipient of that information. Who is the recipient? If I have sent an email to my friend Vikram, I am the originator and Vikram is the recipient. And therefore, there is a one-to-one communication. And the law recognizes now under the Information Technology Act that I, as the author / originator, and Vikram as the recipient, if I have really said something to Vikram in that, or if that document really creates a particular legal threshold for Vikram, Vikram may be entitled to file a legal action. Let's look at another example where I actually create a particular message and I put it up on Facebook, or I create a particular message and I just tweet that message. The tweet may be good, bad, indifferent. Let me assume that I have put something really terrible by virtue of a tweet. I am the originator of that information, but who is the recipient? Everybody who is actually looking at my tweet is a recipient. Therefore, it is one-to-many communication. Therefore, they become the recipients. I become the originator. But the question in law is, who is the publisher? Let me take an example, hypothetical. I put up a tweet calling a particular friend of mine at the bar terrible names. Easily, that information is defamatory. And therefore, this defamatory tweet has been published. If the defamatory tweet has actually gone on Twitter and hundreds and thousands of people have actually viewed it, I no doubt the originator of that tweet. No doubt the 100 people who have looked at that tweet are the recipients of that tweet. However, between these two, who is the publisher of that tweet? Is it me? Is it Twitter? If I put it up on Facebook, am I the publisher or is Facebook the publisher? If I have put it up, let's say on a Google group, which I have created, I create a group and I host that group on Google and it is a closed group and I put up this information. Who's the publisher? Is Google, the closed group, the publisher? Or if it is an open group, anybody can access it, not a closed group, but I create this particular document, which is defamatory and host it on Google groups where anybody, any lawyer can actually access it. Then I am the author. Who's the publisher? Is Google Groups, the open-ended group, the publisher? These questions continue to trouble lawyers over a period of time. And I must say, despite the Information Technology Act, it has continued to trouble us. And I will therefore take one of these illustrations and try and give you a rendition of what does the Information Technology Act say. In our traditional wisdom, for us to initiate any action for defamation, we had to identify the author, we have to identify the publisher, we have to show a court that there is an author of this particular document or author of this particular pamphlet, and so is the publisher of that particular document because it has come up in the newspaper, and that has actually gone and reached the hands of hundreds of people. Therefore, there is publication, so to speak, in common law, and consequently, I am defamed, and therefore grant me an injunction restraining further publication. grant me an order in terms of compensation, grant me X, Y, and Z. The suit is therefore filed against the author. The suit is also filed against the publisher, because dehorse publication, you do not have a cause of action in defamation. Now that is in the physical world. When you know that Sajjan Povayya has written something and Times of India has published that, and that is defamatory towards somebody else, there is a publication that Bangalore has read it, and consequently cause of action has accrued in Bangalore. You will sue Sajjan Povayya, you will sue Times of India, you will get an injunction, you will ultimately get compensation, etc., etc. You may win or lose, that's a different matter. But when you take it away from the physical domain and put it onto the electronic domain and look at it from a web hosted information or a tweet or a Facebook page, who do you sue? The mistake which we do, friends, as lawyers is that we attempt to apply the same traditional threshold wisdom that we have as lawyers to the electronic domain. We use the same logic of the physical domain to the virtual world and try and identify an author, identify a publisher, and start suing them. What we would typically do is that in a Facebook scenario or a Twitter scenario, you will of course bring Sajjan Povayya, who has tweeted, as the person respondent. Then you will bring Twitter as the respondent. You will turn up and say, okay, Twitter has a company in Delhi or in Noida or in Gurgaon. It is called Twitter India Private Limited. So first respondent, Sajjan Povayya. Second respondent, Twitter India Private Limited. And you will go up to court and say, my lord, grant me an injunction. This is defamatory, etc., etc. Get an injunction. The answer is, the question is, are you actually doing the right thing? The answer is no. Because under the information technology domain and in the scenario of web hosted services, the law, the common law that has developed initially in England and the United States of America, and moved now to almost every common law country. Civil jurisdictions look at it a little differently, but pretty much every common law jurisdiction looks at a scenario where on the electronic interface, that is on social media platforms or on web service providers, whether it is the Googles of the world, Facebooks of the world, Twitters of the world, or anybody else, the author and publisher in most cases fuses into one. It is the person who is creating the tweet who is the author. It is that very person who is the publisher. Twitter as a platform is not a publisher, or Facebook as a platform is generally not a publisher. Google as a search engine is not a publisher. And this is rendered from a perspective not just of the Indian Act, but on traditional common law also when it comes to the concept of publication for defamatory actions. I'll take the Indian Act as an illustration and give you a few case law to give this illustration of why and how we can actually effectively sue. The attempt for me, friends, is to share my experience on what is the best methodology by which we as litigators can bring an action and succeed in an action. The Information Technology Act has a bunch of provisions which provides some sort of a cloak of immunity to the intermediary who actually hosts your information. Section 2W of the Information Technology Act defines an intermediary broadly as saying any internet service provider or any party who provides a platform for you to use the internet for publishing, broadcasting, transmitting information, etc., etc. So the platform provider on the internet becomes the intermediary. Who is the originator? You, the person who's creating this the information, is the originator. Whoever accesses that information on the internet becomes the recipient. And between the originator and the recipient, there is an intermediary. And that intermediary I will compare to that of a postal service, for example. If I have written a defamatory letter or if I have written an obnoxious communication about somebody else and sent it by letter to 5 people, and when those 5 people read those letters, there is publication. The question is, does the postman who actually operates as a middle entity which picks up the letter from me and hands over the letter to you, does the postman become the publisher? Answer clearly was no, because traditional concepts of common law applied, saying a postal service does not become a publisher. That is pretty much the logic that is applied to intermediary as well. Section 79 provides a benchmark. Section 79 of the Information Technology Act says, forget section numbers, forget in what way it is worded. Broadly, the benchmark it provides is this: that if you are operating on the internet, you are liable. It is not that only the person who is actually creating the message is liable and all internet operators are not liable. They are liable. However, for that liability, you get a safe harbor. If you come within that safe harbor, you will get an immunity from liability. What is the safe harbor? Just visualize this, friends, in your mind, that this intermediary is a ship. It is generally liable for actions that it will do. However, if it is in a safe harbor, if it has docked its ship in a particular harbor, it will have no liability. Now, what are the thresholds for this safe harbor for an intermediary to avoid liability? It's broadly simple and straightforward. If you are a third-party service provider who provides simply a platform on the internet, then you are not responsible, provided your activity is that of a passive participant in providing the connectivity between the generator of that information or the originator of the information and the recipient of the information, number one. Number two, that you as an internet intermediary, you will not choose who the originator will be, which means that you will not choose who should put this content. So you don't choose the originator. Third, you provide passive role. You don't choose the intermediary, but you also don't choose the recipient. You do not say whether Sajjan Povayya's message must be read by Vikram only or whether it must be read by 100 other fellows. You don't choose the recipient. Therefore, you don't choose the originator. You don't choose the recipient. And the most important fact is that you as a passive service provider, you do not in any manner control or edit the content that is being transmitted through your platform. If Sajjan Povayya calls people names, you will simply transmit it as it is. You will not edit it, which means you will have no editorial control over what is being put. Let's look at a live example. If you have a Facebook page and you write something good, bad, or indifferent, Facebook will have no editorial control. It can have, the technology permits it to have control. But if it has editorial control, it is no more an intermediary, and therefore it will lose the safe harbor of an intermediary to absolve itself of liability. Therefore, it should not pick up the originator. It should not choose the recipient. It should not edit the content. In such a case, it becomes an intermediary within the safe harbor principles of Section 79, and therefore it may not be liable. Then the question is that, fair enough, you are Facebook. There are certain material that has been put on Facebook which is defamatory to me. Somebody who hates me has put up all this information. Because Facebook is an intermediary, it's not responsible. At what point of time will it lose this immunity and become responsible? The Information Technology Act said, under Section 79, 1B, etc., etc., it said that an intermediary is not responsible only until the intermediary is specifically notified that there is defamatory content available on your platform, please remove it. Once the intermediary is notified, then the liability kicks in. If it removes it, very good. It is called, in other words, take down of content. If the content is taken down, it's fine. But if the content is not taken down, it will be responsible. That led to a series of problems. The problems were this. Intermediaries such as Google or Facebook or Twitter, or for that matter, any of these large format social media companies, have millions of users, have hundreds and thousands of content generators. And therefore, if I have put something which is defamatory about another friend of mine at the bar, and that gentleman issues a notice, let's say to Facebook saying, hello, there is defamatory content, pull it down. Is that information to Facebook? Answer is yes. Facebook has now been informed. Can it take it down? The answer is no, it will not, and it should not. Why? Because Facebook, which is a company controlled, let us say, out of California or any part of the US, so to speak, does not know whether this information is correct or wrong. If somebody has written certain information about, let us say, an incorrigible dictator in a particular country. Now that dictator is terrible. He has oppressed people. He is a violator of human rights. He is known for genocide, etc., etc. So people write about him, calling him a dictator, calling him as somebody who flouts the law. Now, if he notifies the social media company or Facebook, if Facebook should take it down, it is actually a disservice to free speech, because you need a platform in which you are exposing possibly the ills of society. You have a right of freedom of speech and expression to do so, and despite that, the intermediary pulls it down. Which means what? If you impose liability on an intermediary, Every time an intermediary gets a private notice from an individual, you are effectively, of course, imposing liability on an intermediary is incidental. You are effectively chilling free speech, because there will be no free speech content available on the internet. Every time somebody writes, every time Arab Spring started and people wrote about democracy as a need of the hour in the Middle East, they could have simply issued a notice and pulled it down, which means Arab Spring would not have a platform. Even in India, when you fight the governments of the day, whichever way it is, you may be right wing, left wing, center, left of center, right of center, does not matter. You continue to fight the governments of the day. If the governments of the day were to simply issue a notice and pull it down, you would really lose the platform to express yourself, which means there would be a chilling effect on free speech. Therefore, the provision of the law which said that upon notice, if the intermediary does not pull down content, the intermediary will be liable, got challenged. We all know Shreya Singhal as a celebrated decision. I must say, because we are from Karnataka and we are proud members of the Bangalore Bar, Shreya Singhal has a Bangalore connection too. Whilst Shreya Singhal was one of the lead petitioners and they had challenged Section 66A in terms of being violative of the Constitution, etc., there were certain members of parliament and politicians from Bangalore who had also raised the very same issue. And in addition to 66A, had raised the issue of what is the freedom that is to be given to an internet intermediary in terms of pulling down content. That is, Section 79(3)(b) of the Information Technology Act was questioned. The genesis was this. The Bangalore petitioners had raised, saying every time there is something available on the internet, if it has to be necessarily brought down because there is a private notice, then free speech will be affected. The platform that is available for expression will go away. Therefore, you need to put certain fetters to it and you need to read down that provision. The Honorable Supreme Court, yes, in Shreya Singhal, not only indicated that 66A is, of course, unconstitutional and therefore should not be applied when it comes to citizens of this country. For aliens, it continues to apply. 79(3)(b) was read down from a perspective of saying that an internet intermediary will continue to have a safe harbor, will continue to be not responsible for content on its platform, despite a notice being given to it by the private individual, because an internet intermediary cannot judge whether that notice is correct, wrong, whether it should operate, not operate, because it has millions of users. Therefore, the Supreme Court crafted a fantastic balancing formula. It said that the only way you can remove the immunity that the internet intermediary has, or the safe harbor that it obtains by virtue of Section 79, that can be cracked and that can be removed only if you have a court order asking the intermediary to remove content, despite which it does not remove, then it has no safe harbor. Second, if a statutorily recognized government authority issues the notice, then if it does not remove, then it will not have safe harbor. That means, I and you, if I have to get a particular content removed from the internet, I have to go to a civil court, get an injunction asking for that content to be removed or the content not to be available pending a trial, and of course ask for compensation, etc. Or in the alternative, write to the computer emergency response team or whichever the notified authority may be by the central government, asking them to communicate to the intermediary to remove. So therefore, typically in a private issue, in a private dispute between X and Y on defamation, X will go to a court, get a court order, and that content will be removed. Or in a citizen to state issue or a state to state issue, for example, fake news coming, for example, across the border from Pakistan regarding India, or news or particular vicious material being put on the internet through bots, through robotic methods by, let us say, a proxy server in Russia. On these events, the government can actually initiate action to pull down certain contents. It is only upon a notice by the governmental instrumentality or by a court order for removal of content, if an intermediary refuses, that is when the cloak of immunity given to it or the safe harbor given to it will stand removed. That was the Shreya Singhal test. Now there are two problems. When the Shreya Singhal test actually came in, it was celebrated because it was possibly one of the first times in the world that with such crystal clarity that a Supreme Court, an apex court of the land, indicated what intermediary liability should be all about. But of course, it is now years, 2015, we are in 2020. But certain problems also originated because of Shreya Singhal. Now the problem was this. At a point of time when Shreya Singhal was rendered, we have seen how social media has grown progressively or with geometric progression over the years. What social media was 10 years ago is not what it is today. And what it is today, it will not be 10 years from now. I do not know. I may sound foolish, but I would dare say that in 20, 25 years from now, teleportation will become actually a feasibility. Teleportation in the sense of a Sajjan Povayya or a Trivikram being teleported from Bangalore to Delhi through pure electronic methods and not through physical movement by sitting on an aeroplane or sitting in a train. Now today, of course, 99% of you here will say that you are a fool, Sajjan Povayya. Fair enough. But maybe 30 years down the line, if we are alive and we have another webinar, I will ask you guys the same question. And I say so because 30 years ago, if I had indicated to certain people that there will be artificial intelligence on the internet, which will attempt to beat the grandmasters like Vishwanathan Anand on chess, people would have said, how is that possible? But the fact is, that is what it is. If I had indicated that, yes, not even 30 years ago, 25 years ago, if I had indicated to you that your car will tell you whether you should take a left or a right, depending upon the destination that you choose, you would have said it is impossible. Today, the fact is that Apple Play, CarPlay scenario or a Google methodology, which is interoperating with most automobiles in terms of your maps, precisely indicates to you which road to take, which road not to take, where is the traffic density more, where is it less, whether you will reach faster or later. Now, that's the scenario in terms of technological advance. Now, compare the Shreya Singhal test to what is happening today. Today, the problem on the internet is not private defamation. It is not about I writing defamatory content about somebody or somebody writing. That always exists. But the problem on the internet today is fake news. Problem on the internet today is unverified information which is leading to the creation of a particular social matrix. Unverified information leading to a particular mindset amongst individuals, communities, etc. Or unverified information leading to human beings orienting their actions in a particular manner. Oh, COVID positive has occurred here or not occurred here. Oh, we are going to have a 15-day lockdown, so everybody run away from the city. Now, most of that are fake news. Now, let's apply the Shreya Singhal test to fake news. Come back to my example. Originator of a content, recipient of a content. In between the originator and the recipient is the intermediary. Now, that applies very well when there is a private communication which is defamatory from the originator to the recipient, and Google or Facebook or Twitter becomes the intermediary. Works well. Please apply the same yardstick to fake news. Who's the originator of fake news? Answer is don't know. It may be a robotic originator somewhere. No. We do not know because we do not have access to the originator. Who is the recipient of fake news? Everybody. Through whom has the news come in? Through the intermediary. Now, if I don't know the originator at all, and there is no way I can know the originator, the intermediary who is in between cannot simply claim itself to be an intermediary and say, sorry, I am not responsible. I do not know, you do not know, but fake news exists, which means that you are rendered remediless vis-a-vis fake news. Because you go up to the intermediary and tell them, hello, I think this is fake news, take it down. The intermediary will tell me, sorry, Shreya Singhal says, go get a court order. Or go to the government, if the governmental authority show notice, I will pull it down. How will you go to a court and indicate and prove in a court, even prima facie, that this news is wrong? Yes, in an egregious news, where they say Himalayas have melted and therefore whole of North India is underwater, there you can prima facie show that it is fake. But whether people are affected by COVID in a particular location, whether they belong to a particular community, don't belong to a particular community, whether they are causing trouble, not causing trouble, how on earth will we prove it is fake? Therefore, I believe that the whole cloak of immunity that the Information Technology Act has given to an intermediary becomes a problem when it comes to situations where communication is not between one-to-one or one-to-many, when the communication is between from an agnostic perspective to many. We do not know the originator and therefore we have a problem. The last issue which I will touch upon before I open it up for questions is this. And this is something which is as a piece of advice to all my friends at the bar. You know, we are proud to be members of this bar. Bangalore and Karnataka are the technology capital of this country. Bangalore in particular has been the uncrowned emperor, so to speak, on the technological interface and development in our country, and continues to lead the way despite all its shortcomings, pitfalls, etc., etc. But if Bangalore is the technology capital and we contribute to a great extent to the technology industry in this country, I ask myself this one question, which always stares at me. Why aren't the courts in Bangalore the leading courts when it comes to technology litigation in this country? It begs the question as to how you can live in a technology capital and not really have a bar or not really have an area of practice which is vibrant, which is technology practice in this city. My respectful submission, with great respect to all of us, the technology litigation or the technology bar or the technology ecospace on litigation side is non-existent in Bangalore. Who has taken that crown? That crown has gone to Delhi. It is the Delhi High Court which has now become the technology litigation capital, so to speak, for the country. Some of the largest technology litigations are fought in Delhi. Some of the most crucial and intertwined litigations are fought in Delhi and not in Bangalore. I ask myself why. Is it because we as lawyers in Bangalore do not have the capacity? Answer clearly is no. We have as much, if not more capacity as our friends in Delhi. Number one. Number two, is it because our courts are not equipped to deal with technology litigation? Answer is again not correct. Our courts are as equipped, if not better, than the courts in Delhi to deal with technology litigation. Then I have always grappled with this. Despite these two indicators being normal, why is that we do not have technology litigation booming in this city? Despite we being the technology capital of the country. In my view, there are two reasons. One, the absence of original jurisdiction to the Karnataka High Court has been a huge dampener in terms of litigations being fought in this, because technology litigations require a particular level of sophistication in terms of how it is dealt with. And unfortunately, you cannot, not that trial courts are not equipped, don't get me wrong, they are more equipped than the higher courts. But the volume of burden of traditional litigation on the trial courts are such that the newer aspects of technology litigation go to the back burner. They don't get decided quickly. Interim orders are not considered quickly, or vacating interim orders are not considered quickly. And even when they are considered quickly and orders are passed, they do not become orders of record, in the sense that High Court being a court of record, those orders granted and refused, etc., become precedents to be used in other high courts and to be used as persuasive value before, smaller benches, or binding precedents before smaller benches, persuasive precedents before coordinate benches, or sometimes even brought to the Supreme Court to saying that so many high courts have taken a particular view and so many else have taken another view. What happens for us in Bangalore is the city civil court's interim order is really not a court, not being a court of record, is really not reported, so to speak, nationally, and therefore does not become a precedent in another matter in another high court. Whether binding precedent or persuasive precedent is a different matter, but it does not. Even a vacating order, where the law may be recorded and detailed orders may be passed by their lordship sitting in the trial court, that does not get the same value and possibly the exposure, so to speak, in legal reporting as a high court order will get. So given the fact that the Delhi High Court has original jurisdiction, most technology litigation, like most information technology and intellectual property litigation, has moved to Delhi. Second most important thing, and here I blame ourselves, the members of the Bangalore Bar, we become very rigid. We apply our traditional wisdom of civil litigation to technology litigation simplicity. As they say, mutatis mutandis. Whatever I know on a civil litigation, I'll apply, which is really a mistake. Let me take an example. Let me assume that Mr. X will sue Mr. Y for a defamatory content which is available on Facebook and which is available on Google and which is available on Twitter. So the defendants will be in the suit. Mr. X, the plaintiff, Mr. Y, who has actually written certain content, and the second, third, fourth defendant will be, you will straight away implead Google India, Facebook India, Twitter India, etc. All their companies which are operating in India are impleaded. What happens in that action is, the Googles, the Twitters and the Facebooks of the world enter appearance and fight it hard by saying that I have an intermediary liability immunity, which are safe harbor, which I have, but that immunity is available not to the Indian company, but to the global company in the US, because it is the global company which controls the platform, the Indian company does not. So Facebook Inc. or Twitter LLC or a Google LLC will, or a Twitter Inc. will come up and say, please delete Twitter India, please delete Facebook India, please delete Google India. They are not defendants who should be here because they are not intermediaries. They don't control the platform. I control the platform. I'm operating in the US. Now what happens? And this I have seen as a live example. I have been amongst you, practiced here for ages. It's only from 2017 that I moved my practice fully to Delhi. The difference in attitude is this. The same issue is in Delhi courts, in the High Court. The same issue is in the City Civil Court, Bangalore. In City Civil Court, Bangalore, when an application is filed saying delete these Indian entities, the plaintiff's counsel will file 20-page objection. No, that is not correct. I want Google India here. Google Inc. will say, listen, I am coming. I am not running away from the jurisdiction. You please implead me. You get an injunction. Please get an injunction against me, not India. But the Bangalore lawyer will say, no, I want Google India also as a party. That kitch-pitch dispute on whether Google India should be a party or Google Incorporated should be a party will take 6 months for the court to decide. Then that will be brought in appeal before the High Court saying this is correct, that is not correct. In the process, the whole primary issue of what is intermediary liability goes to the back burner. Now, what happens in the Delhi court? In a Delhi court, when a similar application gets filed, where Google Inc. stands up through its lawyer and says, I am Google Inc. Google India should actually be deleted. I am the correct respondent or I am the correct defendant. You please implead me defend. As a matter of course, the plaintiff's counsel will say, yes, allow it, bring Google Inc., pass an order against Google Inc. Then render a decision in terms of whether they are liable or not. So this paraphernalia of whether an interlocutory must be heard, not heard, is all put to the back burner and the core issue is considered. And over the same day, when an application is made, the Delhi High Court will take the application on record, delete Google India, implead Google Incorporated and say, now come on, the matter continues. That one day in Delhi High Court will take 6 months in the Bangalore City Civil Court. Who do we blame? We can't blame the law. We can't blame the judges. We can't blame our courts. My friends, we have to blame ourselves. The core issue as to why technology lawyering has not developed to the extent that it should in this country, in this city, is simply because we do not look at the difference between a virtual litigation to a physical domain litigation. We apply the same yardsticks of a physical domain litigation to the virtual litigation. Some of you may ask me, why should we give up control over Google India? How do we know Google Incorporated will apply follow the judgment? The answer is not in whether Google Incorporated in the US will follow your judgment or not. The answer is not on whether Facebook in the US is a good corporate citizen that it will follow a judgment of an Indian court. The answer is in Shreya Singhal. Shreya Singhal says that if you don't comply with a court order, once a court order is communicated to you, irrespective of whether you are a party there, irrespective of whether you have contested, all of that is irrelevant. If a court order is shown to you and you do not comply, you lose your intermediary immunity under Section 79. So Facebook, Google's grandfather, Facebook's grandfather, everybody will comply. The minute there is a court order, they will comply because they do not want to lose the safe harbor that they have under the statute. So therefore, this whole fight about who should be impleaded, who should not be impleaded is irrelevant. Second, it is a matter of course and accepted in international scenario now across various domestic courts that an internet intermediary will submit to a foreign jurisdiction. Please look at the litigations in Bangalore or Delhi. Not a single intermediary, whether it is Google, Facebook, Twitter, you name it, WhatsApp, not a single international intermediary has challenged the jurisdiction of an Indian court to pass an order. They submit themselves to an Indian jurisdiction. They say, yes, we will contest the matter if we should. Otherwise, in most cases, they say, we have nothing to do with this dispute of X defaming Y. We are an intermediary. You please pass an order recording that it is prima facie defamatory. It must be taken down. We will take it down because we do not contest the merits of the matter because we are an intermediary. What they are bothered is, what internet intermediaries are bothered is only to protect their intermediary liability. They are not bothered about the inter se merits of an action. And the minute we realize that, believe me, friends, we will have a more effective litigation strategy, so to speak, that we can bring to bear. The one other point, I know that I'm closing to 7 o'clock and I will stop with one other point. The one other point we should always remember is that we tend to make a mistake in our Bangalore courts where we club into one suit multiple different technological actions. For example, let us assume I am a politician and I am contesting elections. Something really bad about me, obviously when I am contesting elections, good things will be written. Not just contesting elections, my friends, nowadays, whether you are contesting election, whether you are being chosen to become a law officer, whether you are being considered for judgeship, anything, any good thing that is happening to you, there will be 20 allegations made against you and 25 letters written, 25 tweets, 25 Facebook pages, everything. That's the order of the day. Now, in such a situation, if we are looking at a scenario where something is being brought to bear in terms of messages being written, etc., etc., and we land up from a perspective of contesting multiple technology issues in one suit, we have a risk. The example is this: I am contesting election. There is something written about me in a newspaper. There is something told about me in a TV channel, in a TV news channel debate. I am called a gorilla, or I am called a goon. Therefore, newspaper has written it. A TV channel debate says so. A newspaper has an editor. Newspaper has editorial control over what it publishes. And a newspaper is a publisher in law. A TV debate anchor has control. The TV channel has an editor, so he has editorial control. And given the fact that they're editorial control, they become publishers in law. Therefore, in a debate, somebody might say something, they are the authors, and the TV channel which is publishing it will become the publisher. So in the newspaper, I might say whatever, I am the author, but the newspaper is a publisher. Now that content about me is in a newspaper, it's on a TV channel. It is also now available on Facebook, it's available on Twitter, or if you search on Google, you will find all this information. What do lawyers typically do? File one action saying that this is defamatory content, put 30 defendants in that action. Those defendants will include people who have editorial control, people who are publishers, people who are electronic or TV channel operators or broadcasters who in law become publishers, and include intermediaries who are not publishers. Therefore, you are actually clubbing two causes which are absolutely not connected. Your action against a publisher and author is understandable, but you cannot club an action against a third party who is not a publisher and bring him in. So what happens in that action? The minute you have 30 people, out of which 10 people are social media intermediaries, those 10 people file applications saying delete me from the proceedings because I have no editorial control. I am not an editor. I am not the author, admittedly, because the plaintiff says I am not the author. Plaintiff says first defendant is the author. Who am I? I am not the publisher in common law. Why? The Supreme Court now has in Vishaka, Google versus Vishaka, applied the yardstick of the UK courts in Bunt versus Tilley and held that an internet intermediary is not a publisher in common law. Therefore, delete me, vacate the interim order. In the process, your entire matter, the meat of the allegation in terms of your cause of action against various people gets muddied and the case goes nowhere. Therefore, the recommendation really is, it may be the same content, but please bifurcate your cases based on technology. Your cases against newspapers can all be clubbed together in one. Your cases against satellite broadcasting people whose thresholds are different can be in one. And your case against social media should be really a typically independent case on the same content, because in a social media litigation where you file a litigation against, let us say, X who has written something on Facebook, the law is you don't even have to implead the social media player. You can simply file X versus Y. Y has put up a Facebook post against X. So X can sue Y, get an injunction saying that this Facebook post must be taken down, and simply serve that order on Facebook. Facebook is bound to take it down because of Section 79 of the Information Technology Act. You don't even have to implead them. You want to implead them, please implead, because those lawyers also will get work. Lawyers who represent Facebook will have one brief. I think it's in our interest that we implead all of them. But that said, there is a marked distinction in the way you look at technology litigation and internet intermediary liability. Therefore, these are small aspects, nothing great about this, nothing, no astrophysics, but these are small aspects which go a long way in a successful litigation strategy on social media information that is available. And I wanted to share this and really stop at that, because I have spoken, non-stop 1 hour. And I am more than happy at some point of time, if all we lawyers continue to have more time, given this COVID pandemic not leaving, with ease, to do another webinar on any particular aspect of that litigation strategy in terms of what kind of pleadings and what's the law that governs the field, both from a US, UK, and Europe perspective, and what's the law that is in India. I will only say one word and stop. Indian courts have really been in the forefront of technology litigation, despite the fact that Bangalore has lagged behind on it. Some of the best decisions in terms of liability for content on the internet has originated from Indian courts, and they are, if not ahead of the UK and US courts, they are following closely in terms of what the law is and what the rendition is. And I'll be more than happy to speak about it at a future date. Thank you very much for hearing me with this patience and not really terminating your connections and vanishing. With that note, I'll pass the whole platform back on to Trivikram.
Thank you, sir, for a stupendous session, a tireless presentation. In fact, now can we move on to the next session, that is the Q&A session, last part of this webinar.
Certainly, more than happy to receive all questions that are available. And I see some of my friends on screen, after a very, very long time. So it's actually a pleasure to answer any questions that they have.
Sure, sir. Akash, request you to unmute all the lines.
Yeah, panelists can unmute themselves and talk.
The lines have been unmuted. Can we start with the first question? Lines have been unmuted. You will have to unmute yourself, and you can start with the first question. I think Mr. Gupta has already unmuted. Yes, sir.
No, I don't have any question.
Sir, here I have one question. This is Mallikarjun.
Yes,
Hello.
Mr. Mallikarjun, please go ahead.
Sir, very good evening, sir. Sajjan Povayya. There is a stupendous session by you. I would like to answer you, sir. Nowadays, there are in a YouTube, there are millions of contents are there. There are YouTube videos are there. There are so many false things which have been publishing. People are following. If not, suppose the publication is a false, how do we see? Where do we see?
Okay, I will answer that very quickly. There are two issues. One is on jurisdiction, that is territorial jurisdiction. Second is in terms of nature of relief and implement of parties. Now on jurisdiction, the law is fairly settled now that any territory in which this information is available or this information can be downloaded will necessarily have jurisdiction. For example, if a YouTube content which is not palatable to you or which actually violates some rights of yours is available for viewing and access and downloading in Bangalore, your Bangalore courts will necessarily have jurisdiction, number one. Number two, in terms of impleading defendants, you do not have to implead social media intermediaries to get an injunction for taking down some content. In the US, you have the Digital Millennium Communication Act, and of course the Communication Decency Act thereafter, which has a statutory process for taking down content from the internet. In India, we still do not have, so to speak, legislations for statutory content, statutory control of content on the internet, barring, of course, the Information Technology Act providing for certain types of content to be removed, blocking, etc. But in a general private domain dispute, if you sue the person, if you know who has put it up on YouTube, please sue him as the sole defendant, get an injunction saying that that content must be taken down from the social media platform, serve that order on YouTube. YouTube will necessarily within 36 hours take it down, because that's the threshold imposed by the rules under the Information Technology Act for them to comply with the court order. It is not necessary that YouTube becomes a party. But if you choose to make YouTube a party in this illustration, please be clear not to make YouTube India or one of the Indian entities as the party. Please go on to that platform. Please look at the terms of service of the platform and find out who owns the platform. If the platform is owned by a US company, in some cases, platform is owned by Irish companies. Twitter for a long time had a Twitter Ireland company which was owning the platform part of the world. Identify which company owns the platform and implead that company as the defendant. Does not matter if they are outside the jurisdiction. An email communication of summons from court or intermediary in any part of the world will comply. I will take one or two examples. I have represented the Twitters, the Googles, and for example, very recently, multiple Chinese intermediaries who are called upon in dispute. Irrespective of the fact that China and India have had their set of problems, intermediary will subject itself to jurisdiction. The closest for us being in Kerala, there was this case of sprinkler which had certain data in the COVID situation. Sprinkler simply upon notice, Sprinkler submitted itself to Kerala jurisdiction and said, yes, whatever orders are passed, we will comply. Challenge, that's a different matter, but we submit ourselves to jurisdiction. So the gist is, sue the author necessarily, get an order, serve it on the intermediary, it will be pulled down. If you have to also implead the intermediary, implead the right entity of the intermediary. Don't implead a wrong entity, because your litigation will drag on that count.
Thank you, sir. Can we have the next question?
Sir, how to that content of the YouTube, how to produce before the court as a content as a document?
The answer to that very quickly is that with the amendments to the Evidence Act, all that you require today is to print out that content or put that content in a digital media or in a physical media. It may be whatever, it may be your USB drive, it may be burnt on a particular CD, along with a 65B certificate. That's all that is necessary. In most cases, you will not only print it out, but you will also visually display it on possibly a iPad or a screen to the court and append that video in a physical media, which may be a disc, along with a 65B certificate. So that dispute is no more, so to speak, ripe, because it is now accepted that so long as the 65B certificate accompanies that particular content, it will be recognized as the primary version of the content.
Thank you, sir. Can we go ahead with the next question, please? Can we go ahead with the next question, please?
ಸರ್ ನಮಸ್ಕಾರ, ವೆಂಕಟೇಶ್ ದೊಡ್ಡೇರಿ ಮಾತಾಡ್ತಾ ಇದ್ದೀನಿ, ಸಜ್ಜನ್ ಪೋಯ್ ಅವ್ರಿಗೆ.
ನಮಸ್ಕಾರ ದೊಡ್ಡೇರಿ ಸಾಹೇಬ್ರೆ, ನಮಸ್ಕಾರ.
ಈಗ ತಾವೊಂದು ಮುಖ್ಯವಾದ ಪ್ರಶ್ನೆನ ಹೇಳಿದ್ರಿ, ಏನಂದ್ರೆ ಬ್ಯಾಂಗ್ಳೂರು ಸಿಲಿಕಾನ್ ವ್ಯಾಲಿ ಆಗಿದೆ, ನಾವು ಇಡೀ ದೇಶಕ್ಕೆ, ರಾಷ್ಟ್ರಕ್ಕೆ ಮಾದರಿಯಾದಂತ, ಇಡೀ ವರ್ಲ್ಡ್ ಗೆ ಮಾದರಿಯಾದಂತ ಒಂದು IT ಸೊಲ್ಯೂಷನ್ಸ್ ಕೊಡ್ತಾ ಇದೀವಿ. ಆದ್ರೆ ಕೋರ್ಟ್ಗಳು ಸರಿಯಾಗಿ ಸಿವಿಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಮಾಡ್ಲಿಕ್ಕೆ ಅದು ವ್ಯವಸ್ಥೆ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಿ. ಈಗ ಕಮರ್ಷಿಯಲ್ ಕೋರ್ಟ್ಸ್ ಮಾಡಿದ್ದಾರೆ, ಅದೇ ರೀತಿ ರಾಜಕಾರಣಿಗಳ ಕೇಸಸ್ ನ ಮಾಡ್ಲಿಕ್ಕೆ ಮಾಡಿದ್ದಾರೆ. ಅದೇ ರೀತಿ ನೀವು ಕೂಡ IT ಕೋರ್ಟ್ಸ್ ನ ಸ್ಪೆಷಲೈಸ್ ಕೋರ್ಟ್ ನ ಮಾಡ್ಲಿಕ್ಕೆ ಸಜೆಸ್ಟ್ ಮಾಡಿ, ಅದನ್ನ ನಮ್ಮ ಅಧ್ಯಕ್ಷರು ಏನಿದ್ದಾರೆ ಅದನ್ನ ಹೈಕೋರ್ಟ್ ನವ್ರ ಜೊತೆ ತಗೊಂಡು ಅದಕ್ಕೆ ಸ್ಪೆಷಲೈಸ್ಡ್ ಕೋರ್ಟ್ ನ ಸೆಟಪ್ ಮಾಡ್ಲಿಕ್ಕೆ ತಾವು ಸಜೆಷನ್ ಮಾಡ್ತೀರಾ? ಹೇಗೆ ನಿಮ್ಮ ಅಭಿಪ್ರಾಯ? ಮಾಡಿದ್ರೆ ಒಳ್ಳೇದಾಗ್ತದೆ ಅಂತೀರಾ?
ದೊಡ್ಡೇರಿ ಸಾಹೇಬ್ರೆ, ನೀವು ಹೇಳೋದು ಸರಿ, ಬಟ್ ಅದ್ರಲ್ಲಿ ಒಂದು ಚಿಕ್ಕ ಡಿಫರೆನ್ಸ್. ಐ ಥಿಂಕ್ ದ ಪ್ರಾಬ್ಲಮ್ ಇಸ್ ನಾಟ್ ವಿತ್ ಅವರ್ ಕೋರ್ಟ್.
ಕೋರ್ಟ್ ಅಂತ ಹೇಳಿಲ್ಲ, ದಯವಿಟ್ಟು ಕ್ಷಮಿಸಿ. ಅದನ್ನ PD ಟ್ರಯಲ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅದೇ ಬೇಸಿಕ್ ಪ್ರಾಬ್ಲಮ್ ಅಲ್ವೇ? ಅದಕ್ಕೋಸ್ಕರ ಜನ ಬೆಂಗಳೂರಿಂದ ಡೆಲ್ಲಿಗೆ ಹೋಗ್ತಾರೆ. So therefore, you suggest that we should have a separate courts where the expertise will sit and the advocates like you will appear and develop the IT cases in Bangalore so that people can come back to Bangalore.
ನನ್ನ ಅನಿಸಿಕೆ ಅಂತ ಹೇಳಿದ್ರೆ, what is I think more important for us is, see, okay, let's also be candid. We are all lawyers here, so we can have some candid conversation. Now, commercial courts and Namadi, we have realized that has not been a very, very fruitful experience for us in Bangalore. In fact, a commercial litigation was faster in a regular court than now in a commercial court because the court is overburdened. Therefore, my thought process, I'm no expert in this field, but my thought process is, by creating specialized courts or by nomenclature change for a court from being a civil court to an IT court, little or nothing may come about. What is the change that is needed is, I think we as a bar should educate ourselves in the manner in which a technology litigation is to be contested. So I think that continuing education for we lawyers to change our mindset and not apply the same yardstick, whether it is a matrimonial dispute, whether it is a civil land dispute, whether it is injunction suit, whether it is probate, whether it is technology, same yardstick. The same treatment is meted to all the litigation. That I think is a problem. We need to change that stress or emphasis slightly to make sure that we deal with these litigations differently. I'll take one example, Doderi Sabre. The example is this. When it comes to recording evidence on an intellectual property or a technology scenario, we tend to, in Bangalore, apply the same yardstick as we are doing in a Dodbore Gowda versus Sandbore Gowda litigation on 5 cents of land. Saying, oh, you bunny, come into the box, you look at this, you look at that, show him a document and say, is it your terms of service on YouTube? He'll say, no. Who are you? I am YouTube's vice president. You are not responsible for this. You send YouTube's managing director. We go nowhere. What does the Delhi courts do? Today, it has become a practice direction in Delhi also, because Delhi amended its procedural thresholds. They have something called a confidentiality club. The first time I heard of a confidentiality club, I had heard of the Constitution Club in Delhi. I had not heard of a confidentiality club. A confidentiality club is this, that if you're, let us say, looking at a patent litigation or a standard operating patent in a telecommunication scenario litigation, you don't bring that evidence to open court and put it up in open court for everybody to look at it and then lose your confidentiality. The court creates a club of experts from the plaintiff's side, experts from the defendant's side, plaintiff's lawyer, defendant's lawyer, who will sit in confidence under a threshold of maintaining confidentiality, exchange each other's documents, and the experts will then determine what is the criticality or what is the conclusion that must be drawn. So plaintiff's expert will draw a particular conclusion, defendant's expert will draw a particular conclusion. That conclusion becomes a part of the record. You are thereafter, as a lawyer, given the right not to cross-examine some witness of the company. You can cross-examine the plaintiff's expert, the defendant, that is the plaintiff, can cross-examine the defendant's expert and get to the criticality of what the issue is in a particular technical document. And that makes it so much more easier. Why did that happen in Delhi? Because the bar permitted something like that to happen. The bar agreed to that structure. In 3 or 4 matters, that became a court-created structure, and that formed part of practice directions and became a part of the civil procedure code now, which applies in Delhi. That is what we need to do. We, I think, as lawyers, must usher in the change in which, as to the method in which we handle technology litigations. If we do that, we ourselves will actually be a service to ourselves. We will increase the work in the bar and become better lawyers, so to speak. I'm being critical, don't mistake me, I'm a part of this bar, but I think it's time that we learn and we criticize ourselves for it rather than some third party criticizing us.
No, with the due respect, I must make one submission. It is not only the advocates. We have young advocates who are, learned people who are ready to take up the responsibilities and ready to create an environment for IT. This thing. With due respect, I also say the similar way the other side of the also setup also should be there to take up this kind of a thing. Please kindly appreciate that fact.
Correct.
We have a young, dynamic advocates are coming. They are not less than anybody. They are up to anything. But the environment, other side also should be there to understand what you.
Correct. I'll only say this: charity begins at home. I think we should start. Then we can expect the other side.
I hope President Rangnath is on the line and he will take up this issue and create such an environment that young lawyers will come with IT and all these backgrounds and they will do better. Let us create an environment for them.
Correct. I will just stop with one sentence on that. But I must agree.
Thank you very much.
I must agree with Doderi completely on this issue. It has been my experience that the younger section of the bar are far more open to this change and are far more vibrant in learning newer skill sets than the older section of the bar. Therefore, the problem is not the younger lawyers. The problem is we, the seniors. We are stuck in a particular methodology and we believe because we know that methodology, that is the best methodology. Why is that? Because we have not exposed ourselves to another alternate and more efficient methodology. That's all I will say.
I request President Mr. Rangnath, my friend, to take up this issue and helpful as he's always taking up our cause. I'll also request him and also other friends to take up this cause and create an environment in Bangalore so that you also will come back to Bangalore sometime. Thank you very much. Grateful to you.
Thank you, sir. We have a question online. Ministry of Electronics and IT, Government of India issued advisory under intermediaries rules 2011, section 79 to all social media service providers on 20th March 2020 to curb false news, misinformation related to coronavirus. This question is, can intermediaries directly act, that is to remove content without any instance of violation of any law, IPC, IT Act 2000, etc. Can Section 79 IT Act 2000 be applied without any violation of any of its other laws provisions? Request your view, please.
Okay. This is, of course, a very good question, but a fairly complicated question. I would think a detailed answer to this question will take another 20 minutes, but I'll be very crisp in terms of, I think that question is wordsmithed also correctly. There is no way under the present legal matrix that applies in our country, there is no way by which you will remove content from the internet unless you can show that that content violates any law in the land. You should either have a Article 19(2) threshold, that is a reasonable restriction on free speech, etc. 19(2) there are some 8 or 9 baskets in 92, whether it is defamation, whether it is contempt of court, relationship between states, etc., 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 morality, leading to a cognizable criminal offense, etc. Either you fall within that bucket, or you show that a specific legislation or domestic legislation is violated. In the absence of this, the government of India, the Computer Emergency Response Team, or the MeitY, that is the Ministry of Information Technology, etc., and Electronics, they do not have the power under the IT Act to simply, because of their fiat, control content on the internet. Now, if they want to remove certain content regarding COVID, they can do so on the ground that under the National Disaster Management Act, certain thresholds have been built. The news meet those thresholds, and therefore there is a violation of the Disaster Management Act, and to that extent the material must be removed. Now, under the intermediary rules, that is the 2011 rules, which are now of course being subject to amendment in 2020, you cannot remove content unless you can show a prima facie violation of the law. Therefore, ours is one of the few countries where executive authority or executive overreach cannot chill free speech on the internet. Internet is truly free and truly available for free speech in this country, and that makes me a proud Indian.
Thank you, sir. Coming back here online, do we have any more questions to go?
Yeah, Mr. Povayya, Kamalacharan here. Good evening, sir.
Hello, Kamala.
Hi, how are you? Good, good. So it was fantastic to listen to you. Got a very different perspective from especially the practical side of the civil litigation. I may have missed it. Are you saying that while seeking an injunction or other order against an intermediary, they need not necessarily be made parties, and the person who makes the publication is sufficient to be the defendant?
Yes, yes. Answer yes, and I'll very quickly recite why I'm saying yes. Let's take a hypothetical example of I having written something which is terrible against you, and therefore a suit being filed by Kamalacharan to ensure that you injunct Sajjan Povayya from saying anything more and remove this content which is available, let's say, on a Google platform, Facebook platform, Twitter platform. The law is that you don't have to make Google Inc., Twitter Inc., or Facebook Inc. as parties. You will simply make the author a party, get an order from court saying this material should not be available in public domain, and that order, if it is served on Google, Twitter, Facebook, etc., by virtue of Shreya Singhal and by virtue of 79, there is a statutory obligation on these intermediaries to remove it. And if they don't remove it, they lose their safe harbor. So therefore, Sajjan Povayya's write-up is not so important for them that they will lose their safe harbor. They will without demur remove it, because it becomes, so to speak, Kamalacharan, that it is now a statutory mandate that they should remove it rather than anything else. A court order is only necessary because Shreya Singhal says there must be a court order.
So when you say that it is the law that they need not be made parties, it is part of this Shreya Singhal's case, or is it found in 79?
It is by virtue of Shreya Singhal read with 79.
Read with 79.
Don't have to make, I wouldn't say they are not to be parties. You don't have to make them a party to get an order.
Okay,
if you also make them parties, you will be kind to the bar. 4 more lawyers will get briefs. They will appear for them and say, yes, pass an order, we'll remove.
Okay, thank you so much. Thank you.
Thank you.
Do we have any more questions?
Yeah, Trivikram,
Yes.
I have one question.
Yes,
I
sir.
can see Mr. Gangadhar. Yeah. Yes, please.
Good evening, Sajjan.
Good evening. Good evening.
So educative speech it is. My only question would be, Sajjan, you told Bangalore is not a IT litigation hub because of lack of IT professionalism in a bar. Are you seeing that?
I did the professor
of advocates.
in trouble. I have to survive in this bar.
No, not like that. Not sorry. I'm not saying in that sense. I see. For example, cyber police stations. How many cyber police stations we have in Bangalore or throughout Karnataka? In Bangalore also, if you sue any person over some derogatory postings or something like that, or to record the evidence, we need to go to the cyber police station for, I think, 100 and odd times. If he is a small litigant, there ends the matter. Like that, it is delaying and we are fed up of our clients will also lose the faith in us. Don't you think that it is governments of the day is also responsible to help the flying away of the litigation from software hub of India world? Do you
No,
see?
I completely agree. I'm not saying, because we are a bunch of lawyers and we are discussing this matter on an evening, that I have been critical about ourselves in terms of saying what the bar can do. But if you ask me, is the bar the sole person that should be blamed? Answer clearly is no. The problem is that yes, when it comes to police infrastructure, the cyber police in Bangalore is, whilst Bangalore is the IT capital, the cyber police in Bangalore is not the best cyber police in the country. Certainly not. Yes. And therefore, the relating infrastructure towards ensuring that disputes on the electronic domains or social media are controlled and in a coordinated manner resolved, that mechanism does not exist. But if we have to be critical about ourselves rather than blaming others, what stops us as a bar to initiate a process where we ask for cyber police stations to be attached to certain court thresholds? For example, we have multiple courts. We have lawyers who actually specialize in these areas to indicate that, okay, you please denote a particular police station in every taluk, or maybe a particular police station in every district as a cyber police station, which will then have interface with the bar. The bar will actually interact, train, etc. And consequently, there is a particular level of communication between the cyber police and the bar. Today, cyber police looks at we lawyers. There is no difference between a pure play criminal bar, pure play technology bar, pure play information technology bar. There is no difference. All lawyers are the same. Every lawyer is looked at as a generalist by virtue of the police, and every police is predominantly looked at as a bad guy by the lawyers. That really takes us nowhere.
Thank you very much. Why can't we do something, including premier in that field? Why can't you pressurize from your angle to the state governments? So we will also do in our parameters. Thank you very much.
You are right. I have decided after this webinar that the first pressure I will bring is on my friend Mr. Ranganath to now take it up and take it with the government.
Thank you very much, Sajjan.
Thank you very much. I think that with that we are at 7:50, 7:20.
Yes, sir, absolutely. Many thanks to you, sir. My learned colleagues would agree with me. It was a fantastic voyage for last 1 hour. In fact, in between your tight schedule, you have tried to accommodate us today. Thank you so much. And it was a very enlightening session. Thank you.
Thank you very much. It was an opportunity for me to meet my dear friends at the bar. Some of them I have not seen for months. So it's such a pleasure to see all of you, and look forward to meeting all of you in person once this so-called Corona Mahamari vanishes. Thank you very much.
Certainly, sir. Thank you, sir. With your permission, we'll be logging off.
Thank you. Thank you.